Welcome to the Capstone Conversation, where you learn about what's happening in the greater East Bay. I am your host, Jared Asch. We are going to be talking about land use and the Bay Area housing crisis. I think most people acknowledge there is a crisis going on and that we need to build more. Where do we build more? That's a big question. How do we do economic development? Today, we're going to talk about housing with two land use attorneys focused on housing. I'd also recommend going back and listening to an episode with Lisa from the Building Industry Associations. But today, from the Fenimore Law Firm, we have Patty Curtin and Amara Morrison joining us. Thank you, ladies, for joining me.
Thank you, Jared, for having us.
Do you guys want to tell us a little bit more about yourselves and your backgrounds?
Patty has been practicing land use law for about 34 years, mainly focusing in the Bay Area, but throughout California and a little bit in Nevada. Born and raised in the Bay Area, so I've seen an awful lot of growth occur and changes occur since 1962. I've practiced with several different law firms, both big and small, representing private clients, meaning landowners or developers, and also some public agencies. So I work both sides of the fence. I was also a planning commissioner for the city of Lafayette for over 10 years.
Great. And Amara?
Thank you. I have a slightly different path to my current career as a land use practitioner. I spent about 25 years as a city attorney in two East Bay cities, Livermore and Walnut Creek. While working as a municipal law attorney, I was assigned to work with the planning commissioners and also with city council on land use matters, and have been very interested throughout my career in development here in the East Bay. Since joining Wendell Rosen, which is a precursor to Fenimore, I have focused on representing private clients in connection with their residential development, their commercial development, industrial development. And I also serve as general counsel to transportation agencies here in the East Bay. So I get to use a little bit of my municipal law practice currently, even though I'm with a law firm.
Talk about an overview picture of the housing issues in the East Bay and throughout California from the land use perspective. Where is this problem stemming from? Why is it here?
I think it goes back to after World War II, the Bay Area was ripe for growth and there was a huge housing boom. The houses started coming up, and as they came up all over the Bay Area, all over California, all over the United States, but just focusing here, when something happens that quickly and with that kind of power, zoning regulations and land use regulations came into effect. There was some restrictions put on where to build, how to build, when to build, and things of that nature. That's when land use really got its grasp in the regulatory fashion. Here we are today, many years later, dealing with what we call the housing shortage, but this started way back. I guess it was 1980s, actually, when the Housing Accountability Act was first put into place. And that's when we recognized for the first time the housing shortage, and that was 40 years ago. We've been dealing with this issue for a really long time. To put it in perspective, in 1965, a 4-bedroom, 3-bath house in Walnut Creek on a half acre was $24,000. Today, it's about $3 to $4 million.
I think there has been dramatic economic growth in the Bay Area, particularly in Silicon Valley. It has resulted in an excess of jobs without a commensurate supply of housing. It's a simple issue of supply and demand. There's built up demand for housing units and affordable housing units. I'm not even referring to affordable housing units with a little a, but really kind of market rate housing, which is accessible to middle income individuals. There's that demand with little supply in that area. And what it has done is really forced other areas to accommodate housing in those areas, results in people having to commute for very long distances. In the last 10, 20 years, jurisdictions have really striven to accommodate some sort of a jobs housing balance. We're still very much out of whack. It's why we're seeing people commute from the Central Valley to higher paying jobs in the East Bay and even San Francisco.
Amber brings up a great point. It's this job housing balance. And I remember hearing it for the first time years ago in the land use context. And there were job housing balance ordinances. First one I worked on was in Sacramento. But the hard thing was the jobs developer is not usually the housing developer. One person doesn't develop both. It's very hard to get that balance.
I did a West County podcast episode with the mayor of El Cerrito and the mayor of Hercules, and they were talking about how their communities, which were strictly residential and shopping for those residents, have totally been transformed post-COVID because people are home 5 days a week. They're home 2 days a week, not necessarily making the commute into San Francisco anymore. And there's a need for more services related to them, more businesses, more lunch places. So that they talk about the job imbalance, right? There wasn't the jobs out here. Everybody used to commute that lived out here. We were a bedroom community.
Very interesting.
When you look at land use, you have a number of cities in the East Bay who have been opposed to new housing. Some cities have been more willing to embrace it. Was that part of the problem that we're all facing, the desire to keep our communities the way they are and making the shift to account for, hey, we all want to live here?
It's the wannabes and those who are here imbalance against them, right? But it really took the legislature's involvement to bring that issue to the forefront. Some jurisdictions were not approving housing that was different than what already existed in their communities, i.e. more affordable housing or different type of housing other than your single family homes. The legislature stepped in and said, you're going to have to start preparing housing elements that have all this kind of criteria in it. You have to have housing for the special needs. You have to have housing for these different income levels. You have to have housing for anybody who wants to or can come to this community. That took a while to develop because it was like 20 years ago when those housing elements were being drafted, they became more prevalent in what we call our general plans, where the land use element used to be the dominating element. It became the housing element. Now that we have HCD, the Housing and Community Development Department, involved in certifying every jurisdiction's housing element, they're going to make sure it meets all this various criteria. Now agencies are forced to implement these measures. Now there are many, not only the decision makers, but the local residents that are fighting it. They don't want the legislature telling them what to do. And it's because they want to have their own local control. I think I'm finally seeing that die out a bit, and they're finally accepting that these are the laws and they need to follow them. I find it most difficult when we go to some jurisdictions where they either don't understand the law or they don't want to understand it. It takes a lot of time to educate them on the new laws and what they can and can't do.
Patty's absolutely right. From my time in the public sector, I worked closely with planning departments as they were developing housing elements. I remember in the early days, it was more of a paper exercise to identify potentially developable sites and different densities than those parcels had been zoned in order to accommodate housing. But 20 years ago, it was simply more of a paper exercise. And since the legislature, I think, has mandated that HCD take a more active enforcement role, jurisdictions have taken their responsibility to develop actually implementable housing elements very seriously. We've all been hearing a lot about builder's remedy, a provision of the Housing Accountability Act that's been in the law for a long time, but has only recently been utilized by developers as a way to propose projects in jurisdictions that don't have a housing element which has been certified by HCD. And we might get into more detail later on about that particular provision of the law that has been used quite a bit, kind of more in Southern California and to a certain degree up here in Northern California as well.
Let's dive in.
Okay.
Builder's remedy, how is that impacting some of these cities? And how many cases are there actually going on?
The East Bay Times published a list not too long ago. It's probably more prevalent in Southern California for jurisdictions that do not have a housing element certified by the state's Housing and Community Development Department. A developer can propose a housing development provided 20% of the units are affordable, that is not in compliance with the general plan, is not in compliance with existing zoning. If there's a blank slate and a jurisdiction has to make certain findings, which are fairly difficult to make in order to deny those builders' remedy projects. We currently are processing one, not here in the Bay Area, but in a jurisdiction that has only recently come into compliance and is actually having to process now about 20 builders remedy applications. So what we've seen more in Southern California are instances in which a developer has been trying to process and entitle a project, a large scale project in a jurisdiction, has not had cooperation from the local agency, and in a non-compliant jurisdiction uses builder's remedy as a way to leverage some power over the jurisdiction. Like, here's my builder's remedy alternative, which is going to be very difficult to deny, willing to submit this to the city unless the city is willing to come to the plate and consider processing and approving what many might view as a more reasonable alternative. We're not representing folks right now who are using it in a strategic manner, but rather who are just using it in a manner in which it was intended, which is for non-compliant jurisdictions.
I just pulled up that article from the East Bay Times, and I'll add it into the show notes. It's a couple dozen projects, and if you take out 2 or 3 cities like Saratoga, which has 40, it's less throughout the Bay Area. I was talking to one builder recently, and he's, look, we filed it because we had to, but our goal is, with or without the city, to still have a community benefits package, still work with neighbors. And so now, instead of the city denying us, they could choose to become our partner because we forced their hand with a builder's remedy project. We're going to do what's right for our neighbors. What do you want an elected official to know about where not to step to screw up in the future on builder's remedy?
It's not necessarily the jurisdiction's fault that their housing element wasn't certified on time. This process is grueling. It is really difficult. And the folks at HCD are doing the best job they can as well, but sometimes there's a staff turnover there, and their idea of what should or shouldn't be in the housing element is different than the last staff person, and then it takes a much longer time. So the penalty only goes one way. The penalty goes to the jurisdiction, not to HCD for maybe not being consistent. That's the process. What can they do? Start earlier? The cities don't have the money to do this, to draft housing elements for 2 years. Once they draft that, they have to rezone the land to make it higher density generally, because you're trying to accommodate more housing, put in different policies to provide more affordable housing. It's constant. I don't know if there's really anything else the jurisdictions can do.
I just want to echo Patty's sentiment that there is staff turnover at HCD, but I just want to also point out that local planning staff is also really overworked. There have been a whole slew in the last 5 to 7 years of new housing legislation that planning staff have to get their arms around, get familiar with, maybe even process development applications pursuant to. And I think staff does the best that they can to develop a compliant housing element. But unless a jurisdiction has ample resources to hire planning consultants, the burden falls very heavily on local planning staff. And it's tough.
It is tough because the city's required to hire these consultants, so that's where their monies are going instead of hiring their own staff to do it. But even if their own staff is doing their housing element, that takes away from them processing housing applications. So it's a vicious circle.
I know one city in Contra Costa that said they got a staff person that said, okay, if you're good on your final draft, make these 3 changes. submit it back to us next week. We'll get you approved. You'll make the deadline, no problem. They did submit it on time. They made the changes. They believed it was approved. And then staff was on vacation for 2 weeks and the deadline passed. And builder's remedy project got filed. While that person was still on vacation before it was approved, the developer jumped on it. And there's a lot of animosity over, hey, it was submitted. That's not our fault. I know another city in Solano that was dealing with, we submitted our housing element, but we had 3 staff over the course of a 2-year period. Everybody gave us different feedback.
Yes.
I heard a lot of
With
those stories. I want to touch back to something you brought up, Jared, and that is how developers, I think for the most part, don't want to force a project in a jurisdiction that is not going to be compatible or acceptable to neighbors. There's always going to be a tension, anytime there's a new project, there's going to be some reaction and resistance to it. But I think most of the folks, at least that we work with, are reluctant to supercharge density, or as they would be able to do under builder's remedy, or really propose a project that's going to not be palatable and not be acceptable in the long run to the jurisdiction. Because a lot of times these developers are very locally based, and it's not going to be just a one-off project that they're seeking to get approval for. They want to be a good partner and a good neighbor and continue to do work within a jurisdiction. Just wanted to note that.
Yeah. And also, builder's remedy doesn't mean you're going to get that project approved. That just means you could go in with a project that's inconsistent with the land use regulations. The two that I have seen is housing in an office park, because you couldn't do that because it's not office, and office isn't being utilized right now. That housing project still has to go through the whole public hearing process, the California Environmental Quality Act, and everything else. The developer doesn't want to cause enemies from the beginning. They do want to work with the community, most of them.
Let's talk about an example of that where developer has tried to work with the community, but maybe the community didn't want them anyway. We're going to give a case study here for the listeners of the Deer Hill project in Lafayette, which has been trying to go on, I think, for 12, 13 years trying to be built. Tell us a little bit more about that background of a project and what you can share with us.
Sure. You want me to start, Amara?
Sure.
Oh, it's probably more like 20, 25 years. This is a project in the city of Lafayette. It has various names. One's Deer Hill. The other one is Terraces in Lafayette. I know, Amara, you mentioned another one too earlier, another name that it had. But anyways, it started out in 2011 with an application for 315 apartment buildings on Deer Hill Road, on the corner of Deer Hill and Pleasant Hill Road. And the community went wild. They didn't want 350 apartments on this property in Lafayette. They alleged that it would cause too much traffic, that Alcalanes High School's across the street, and you got busy Pleasant Hill Road that many commuters use, not just the residents of Lafayette, but it draws in traffic from everywhere. So they were very concerned it was going to be a huge mess. As the opposition got, our city manager of Lafayette sat down with the developer's team and said, maybe there's another project we could do here, something that's not so large that the community could embrace. The developer came forward with a smaller project of 44 units and a dog park and some other things, and started processing that project. But what the developer did do in the city was make an agreement that if that 44 unit or smaller project wasn't approved and came to fruition, then they could fall back on the 315 apartment project applications. Both applications were alive, for lack of a better word. They processed the unit, and I'm going to let Amara talk about the various litigation because that provoked the first piece of litigation. But in the end, that 44 unit project was approved. But then the residents of Lafayette started a referendum campaign to overturn that decision, and they were successful. And mainly, the folks in Lafayette believed that if they got rid of the 44 unit project, no way would that apartment project come back, even though they were well informed that it would. And lo and behold, when the 44 unit project was invalidated, the 315 apartment project popped back up. And it was approved. And then we had lawsuit number 3, which Amara will talk about. And ultimately, the developer in the city, because they approved the project because it was a SB 330 project, it was consistent with the general plan and the zoning, even though it was more density than the smaller project. And lo and behold, that project is now beginning to come to fruition and the grading is beginning on that property.
I think the project also gave fuel to an organization that had been brewing in the background. That is, I think it started out as the Bay Area Renters Foundation or and also Carla, which I cannot now exactly remember the acronym's name, but essentially these organizations came together and became a movement, which started here in Contra Costa County and is now apparently spread, if not nationwide, globally. And it's the Yes in My Backyard, or YIMBY movement. When the city approved the 44-unit single-family project, Carla / the YIMBY group filed litigation saying the project is not enough. You're actually depriving future residents, potentially 700 future residents, of a place to live. And those future residents have no voice. And so we are filing this litigation on behalf of these future residents. That litigation did not proceed. Carla lost. And as Patty indicated, the 44-unit project was proceeding until Save Lafayette, a local citizens group, filed a referendum. It has been the tortured history on this project, and I think a case study of how local opposition can, if not completely eliminate necessary density, eliminate valid projects which are valuable within a jurisdiction.
I just want to say also, Jared, is that project in that 10-year period or 20-year period endured over 100 public meetings. So this developer who's building the 315 apartments is already paid millions of dollars in attorney fees, the city's fees, processing fees, land fees, in holding on to this property for this many years. And now they have to construct it. And with the cost of construction and being as high as they are, I don't know how they're going to be able to finish this project and rent it. I can't imagine they're going to make any money, but that's a problem.
And the interest rates, right? Even though the news came out that the Fed has reduced interest rates by 0.5 point and may further that this year, that's not significant. It's not what it was 6 years ago even, and those costs have gone up. You're talking now probably like just $1 million a unit to build cost. If you're tacking on $250,000 over 350 per unit, over 300 units in legal fees and community outreach and time lost.
Yeah.
And at least $250,000 to $500,000 per unit, maybe in all of those.
That's right.
Am I off in my numbers?
The price per square foot to build here in the Bay Area is $700 to $900. If you're going to build 1,000 square unit for 1,000 square feet, that's $900,000 or $700,000.
It's important to note that for projects that include really important affordable units, there is no break on the construction of those affordable units. Those affordable units cost every bit as much as the market rate units. The homes at the terraces at Deer Hill, the apartment complex, include 63 affordable units. Just do that math.
And that money has to get spread either to the tax base through grants or to the other units. And there's the benefit of those affordable units for the people who need them, but it just continues to spread that cost. When you say $700 to $900 per square foot, does that include the years of litigation and community outreach and other public benefits?
It does include developer impact fees. Those are the fees that go to the schools, fire, police, library, art, transportation, but it does not include the processing costs, litigation costs, consultant fees, the price of the land. No.
Let's talk a little bit about that. When you work with developers, what do you see in terms of public benefits and public impacts? I know there's a project going on in my neighborhood, and somebody was asking the developer for $1 million on 28 townhomes, and they're like, that's a little much. How could you work with us on that number? Where did that come from? And I don't think they understood the developer still has the school fees, right? Still has transportation impact. Can you just explain a little bit about that and what people should know?
Emery, you want?
I can say that I've worked on projects where we've gotten all the way through probably a second planning commission hearing and ask a community edits package. The developer has factored in, created its pro forma, figured out the ultimate cost to process the project, and then literally at the 11th hour to respond to a community's demand for a community benefit package. The calculation is, do we just say no and push it to the city council and hope that the city council isn't going to impose some or all of this community benefit ask, or do we just negotiate as best as we possibly can? And I think there are some jurisdictions understanding that there is this sort of late hit and late ask from residents and from opponents are starting to try to create a benefits package as a part of their land use ordinance. I think that's challenging because different jurisdictions are going to have different asks and different demands. I have counseled my clients to understand that there needs to be some percentage of project costs that they have to think about applying to a community benefit.
What is a public benefits package for the people who don't know? What are some typical elements that go into it?
Patty, do you want to take that?
Yeah, absolutely. With the new legislation today, it is very difficult for a jurisdiction to enforce the community benefit packages because they are not objective standards for most of the projects that need to comply with those. The community package, like Amara was saying, is already created by the local agency in the requirement of art fees, childcare fees, park fees, school impact fees, transportation fees for police, for fire. Oakland even has one for litter pickup. All these fees that are already imposed on the development that have to be calculated in, and in the requirement to provide affordable housing. Most housing projects with 5 to 8 units, Amara, have to have 15% of their project affordable housing. And that percentage is also a community benefit because the developer or the people who buy the market rate are subsidizing that housing.
I've helped negotiate some of those and look for library donations, or can you build something at a school? Things like that, just to make neighborhood improvements and then communicate that back to residents. Hey, this developer is part of this community. They care. They're not just here for the profit. They're listening to you. You mentioned, Patty, SB 330. You want to talk a little bit more about what that is and its role?
That was a piece of legislation that came out a few years ago that amended various sections of our land use laws. But I think the most important one is, or the most important aspects of that law was, it said that if you have a housing project, and it only applies to housing projects, both affordable or market rate, or affordable and market rate, it could be a mix. That basically says if an application comes forward and it's consistent with both the zoning and the general plan, then it needs to be processed. Only those objective rules that are in place at the time it was filed can be applied to the project. In other words, it takes out the discretion from the planning commission or city council to impose something that's not already in writing. They can't say, oh, you know what? Our library now needs to have another story put on, so we're going to ask you, developer, to fund that. They can't do that unless it's already a written policy in place at the time the application was filed.
It also imposes a 5 meeting or 5 hearing limit. So going back to what we were discussing about the homes or terraces at Deer Hill, having to go through upwards of 100 different public meetings and hearings, SB 330 caps the number of meetings that a housing development project can be subject to 5. I think that's really helpful. And it also imposes some very strict timelines on both the applicant and the local agency to turn around comments around incompleteness, which really helps. I think both Patty and I worked on plenty of projects where we'll get comments back from the local agency, from planning staff, and it seems like it's a constantly moving target. You'll address one area of incompleteness. The next round of comments back from planning staff include a whole new range of incompleteness issues. SB 330 attempts to really limit that and truncate that. We think that's to the benefit of developers as well.
Yeah.
I've heard that come up before, is the goalpost keeps getting moved. If there's 9 staff that need to have comments, don't submit us comments 6. And then when we think we're done, add 3 more sets of comments, right? Get everybody to the table at the same time. Get organized on your side. We'll work with you, but that improve the communications is a good message to the city.
I did work for a jurisdiction that had a really great model. Any project of a certain size or scale was subject to a weekly meeting with all of the relevant staff, sitting around the table, talking, discussing thoroughly the project, the potential impacts. And so all of the comments could be gathered and returned to the developer in one fell swoop. I think that's a great model that I wish more jurisdictions would adopt.
And there's some bonuses that developers get, like a density bonus. Could you explain what those are for the listeners? What is the density bonus and what are some other bonuses out there?
That would be a 3-hour podcast. They only get a density bonus for housing projects if they provide a certain percentage and level of affordable units. So they have part of their project, they have to have an affordable component. And without getting into the weeds, there's various levels of affordability, very low, moderate, and very low, which I don't see much anymore. They could have extra units to make it financially easier to provide these affordable units. Amara, you could talk about the waivers and concessions, what they get. Maybe that'd be helpful.
Sure. Depending on the level and extent of the affordability in the units, a developer is entitled to a certain number of concessions and waivers of development standards. The easiest way to think about a waiver of a development standard is if you have a box that's 3 stories high, which is subject to a 3-story height limit. Through density bonus, you can ask for a waiver of that height limit to incorporate those additional units into your housing project. The waiver of development standards pursuant to density bonus law is really powerful because it allows for some flexibility in those standards, which would otherwise constrict the size and scale of a project. Again, it's all for the provision of these affordable units. We've seen more willingness on the part of our developer clients to rely on state density bonus law. It does come at a cost, talked about earlier in the podcast, because those affordable units are every bit as costly as the market rate units.
That's helpful. Before we go, any words of advice you want to give to cities or developers in moving forward to address the housing crisis here? What should people be paying attention to in the next 6 months to 3 to 5 years to adjust this?
The statistics are out there that we need 3.5 million more homes in the state of California by 2025. That's just around the corner. How do we do that? We need to provide more housing all across the board, affordable housing, market rate housing, different size housing. Affordable housing need not be done as fully as it's being done today. It could also be done by design. Not everybody wants to live in a big ranch style home. They want something smaller. So having something that's more affordable to that person is really important. But I think it's the developer, and I think the developer knows, but I think it's the jurisdictions and the communities who live there to understand that this is it. This is what's going to happen, and stop fighting, because it's just costing everybody a lot of money, a lot of time, and all of us are paying for it.
Yeah. And I think the state of California is going to have to spend some time on CEQA reform. There have been many pieces of legislation intended to streamline approval of eligible housing projects. By streamlining, we mean being able to bypass typical California Environmental Quality Act review. But traditional development projects are still subject to CEQA and challenges under CEQA. And there has been a study that came out within the last couple of years that indicated 50% of the units approved from 2018 through 2020 have been the subject of litigation under CEQA. I personally feel, and I think Patty would agree, that there has to be some concerted effort at revising CEQA and how it can be used as a sword against valid projects.
Did you say 50%?
Litigated under CEQA because it's an easy statute to litigate. But I'll just to give you an example. We have a 13-unit project in a local jurisdiction here, and it's been on the books in 2 different jurisdictions for 6 years. It's a mitigated negative declaration that they've been processing, which basically means the homes will not have a significant impact that can be mitigated, but yet it has taken 4 years to make that determination. That's crazy. You're talking about 13 homes in an infill area. That is what we're dealing with when it comes to the California Environmental Quality Act. The legislature knows that this needs to be looked at. It's just such a big beast, and it's hard to get your arms around. And there's so many people involved in it. There's the environmental groups. There's the community leaders. There's the labor unions that all want a piece of it. We just saw the frustration from the legislature. They exempted their own capital, CAPIT, improvement project from CEQA. So they realized the difficulty in it. And because it was subject to various CEQA lawsuits when they first started coming out of the box with the project. And so we all know it's a problem, but we just have to deal with it. Got to do something.
Yeah, that might be worth another episode in the future, is how to reform CEQA, because it comes up in the business environment as well as for developers, right? It impacts hospitals, transit, housing, commercial development. It definitely needs to be discussed more, but it's not an easy thing. Thank you, Patricia Curtin and Amara Morrison from the Fenimore Law Firm. I appreciate you both being here and sharing your thoughts and taking time out of your day.
Thank you so much for hosting me.
Enjoyed it.
Yeah. Wait, don't leave yet. Hit subscribe. Make sure you get the weekly updates. We have a new episode every Wednesday for stuff happening in the East Bay. In the meantime, follow me on LinkedIn, Jared Asch, or check out our firm where we have a weekly newsletter and blog at Capstone Government Affairs on LinkedIn. Thanks for joining us today on the Capstone Conversation.